It's the Brian Lehrer Show on WNYC. Good morning, everybody. I'm Bridget Bergen, filling in for Brian today. The Supreme Court term has ended. The final opinions are out. And as you've undoubtedly heard this morning, the Supreme Court struck down President Trump's executive order that sought to end birthright citizenship. They also issued rulings on trans athletes and campaign finance. So to dig into these rulings and their implications going forward, I'm joined once more by Emily Bazelon, staff writer for the New York Times Magazine and a co-host of Slate's Political Gabfest podcast. She's also a senior research scholar in law at Yale Law School and the author of Charged, the new movement to transform American prosecution and end mass incarceration. Emily, welcome back.
Thanks for having me.
All right, let's start with the most anticipated case, birthright citizenship. It was the last one announced, and the majority of justices said President Trump's executive order was struck down. Chief Justice Roberts wrote the majority opinion. Tell us who joined him.
Justice Barrett joined him, a fellow conservative, and so did the court's three liberals, Justice Jackson, Justice Sotomayor, and Justice Kagan. Brett Kavanaugh concurred in the judgment, so he agreed with the overall result, but he did not agree with the majority that the Constitution protects birthright citizenship. He based his opinion on a law that Congress passed in 1940.
Interesting. Listeners, do you have a question for Emily Bazelon on the cases announced today, or do you want to weigh in on this now concluded term? You can call us or text us at 212-433-WNYC. That's 212-433-9692. Emily, I think from what I understand in some of our preview conversations, certainly yesterday, this was expected based on oral arguments, but, I can say from our first segment where we were talking about another Supreme Court decision that related to TPS, there's certainly a relief for many people who felt that, this could be a decision that would affect millions of people, for individuals who felt that their citizenship could have been threatened, even though the executive order would have only applied going forward. Is that right?
Yeah, I think also it felt like a kind of core aspect of the country's identity was at stake. Birthright citizenship has been foundational to how I think we think about America, the idea of accepting anybody who's born here without any ifs, ands, or buts. And all of that seemed up for grabs. And then I think also there was this question of whether a president with the stroke of the pen could unsettle this historical understanding, based on language that Congress put into the 14th Amendment way back in 1868. So I think that explains why it felt so high stakes.
And as you mentioned, in this 6-3 decision against the president, Justice Kavanaugh's dissent seemed to leave room for Congress to be able to change the law, in which case this would be 5-4 upholding a constitutional right to citizenship if you were born here.
Yes, that's correct. I mean, the statute is important. It gets you to the same result, but it's a lot easier to change a law than it is to amend the Constitution. And so the distinction that Justice Kavanaugh is making is important. His basis for birthright citizenship is a lot shakier than the one that Justice Roberts put into law for the majority.
Okay, so then can you talk about what were some of the reasons given in the dissenting opinions?
Yeah, the dissents are picking up on a kind of revisionist line of scholarship that has been arguing that citizenship turns on domicile. And domicile is having a permanent home in the country. In other words, if you come here and you're here legally and you have permanent status as parents, then yes, your children receive citizenship. But if you're here illegally or, temporarily, then it doesn't apply. And this is all a reading of this, these 5 words in the 14th Amendment subject to the jurisdiction thereof. This question of what that means. And I think what the majority really shows is that almost entirely the examples have been, that for an exception to birthright citizenship, okay, if you're the kid of a diplomat who has diplomatic immunity, then you're not subject to the United States laws. Or if you're the child of a hostile invader, then you wouldn't be subject to the nation's laws. But everybody else is subject to the nation's laws. So that was why the majority, I think, stuck with the traditional understanding of birthright citizenship. But the dissents argue that there's some evidence in the record, and I would say that it's thin, but some evidence that actually there was a more limited understanding all along.
I want to bring in George from Manhattan, who has a few more questions on the dissent. George, you're on WNYC.
Yeah. What I'd like to know is what Constitution are the three dissenting judges reading? I mean, the 14th Amendment is very clear. If you are born here, you are a citizen, regardless of whether you're here illegally or not. And who are the three dissenting judges? I know Kavanaugh has an issue with federal law vis-a-vis Constitution. So could she explain that, please?
Yeah, sure. So the dissenting justices are Alito and Gorsuch and Thomas. And they're arguing that this phrase in the 14th Amendment, subject to the jurisdiction thereof, creates like a big giant exception to the rule of birthright citizenship. And then the idea here is that all along, Congress did not intend for people who had come here temporarily or illegally to have birthright citizenship. One problem with that reading, there are a bunch, but one is that we didn't really have the same concept of illegal immigration in the 19th century. The borders were much more porous. And so, that's one of the kind of ahistorical aspects of the dissent's reading, I would say.
Emily, the president attended the oral arguments in this case, and it seemed to realize then he was going to lose. Have we seen any reaction from him yet? I haven't been able to watch Truth Social while the show's been on.
Yeah, that's a good question. Me neither, because I was writing something. But I'm sure he will weigh in at some point soon. And, one thing about this executive order and Trump's approach to this issue is that it was always a far-fetched legal argument, but it was also for him a kind of potent political appeal to the MAGA base. Justice Alito really picks up in his dissent. He's complaining about what he calls, birth tourism, this idea that people just show up to have a baby and that this is a huge problem and the country needs to crack down on it. That notion was part of what got Donald Trump elected.
Let's talk about some of the other big cases, two other big cases that were significant. The first opinion they announced this morning had to do with the issue of state laws banning transgender girls and young women from competing in women's sports teams. There were two separate lawsuits, one in West Virginia, one in Idaho, that claimed that the laws were wrong. One case hinged on Title IX anti-discrimination protections, and one that put the 14th Amendment Equal Protection Clause at its center. The court has expected, ruled in favor of those states and against transgender athletes blocked from participating in girls' and women's sports. Any surprises or nuances to the decision there from your perspective?
Yeah, well, one surprise I would say is the composition of the ruling. So there, like you said, there's a Title IX part of this case. Title IX is the federal law that provides for sex equality or lack of sex discrimination in sports. Then there's this question about the Constitution. On the Title IX part of the case, it was actually 9-0. All the justices agreed that Title IX and its regulations allow for sex-segregated sports and then allow states to define sex in terms of biological sex. I thought that was surprising, that there were no liberals in dissent on that point. Then the second part of the ruling about equal protection, there was a 6-3 divide, conservatives versus liberals. The majority opinions by Justice Kavanaugh, and he says the Constitution doesn't require the states to make an individual comparison of physical and athletic capabilities of all the people who want to play youth sports. In other words, the middle schooler in this case was arguing, look, I started taking puberty blockers before I had puberty, and so I don't have any male advantage. And yet I'm being treated differently on account of my sex. And the majority says, like, no, the states don't have to go and sort that out for you. And the dissent, and it's by Justice Sotomayor, joined by Kagan and Jackson, so all three liberals, they say that's a mistake. This case should go back to the lower courts so that they can establish whether this particular plaintiff really does have an advantage. Because the state is justifying this law in terms of the safety to athletes of girls who would be on the team, and then also competitive fairness. And so the liberal justices are saying we just don't know enough based on the facts that have already been established to understand how that state interest really intersects with this kid and what this trans girl wants to do. So that was the divide on the equal protection claim.
Given that in the oral arguments for these two cases, as you mentioned, the conservative majority seemed to agree with Idaho and West Virginia laws, it seemed the question today was just about how broad a ruling this could be, and they didn't go so far as to say states have to restrict girls' teams to only biological females. Was that at risk here?
It wasn't directly at risk. I mean, it would have been that wasn't briefed. It wasn't part of the case. That would have really been, I don't want to use the word crazy, very unexpected if they had gone that far. There could be another case like that on the way, but it was not part of this case. I think the other thing about this decision is it did not say that transgender people can never be considered a protected class for purposes of equal protection law. So that means that, you're protected from being treated differently by the government without a very, very good reason on the basis of race or religion or sex. The court has never extended that protection to LGBT people, but that question remains open. So that's like a bit of a relief, I would say. On the other hand, the 9-0 Title IX part, I think, is probably dismaying to the lawyers who brought this case.
Well, let's move on to another case the court issued an opinion on this morning. The court overruled a previous opinion in a campaign finance case. This was about whether federal limits on donors coordinating with political campaigns are a violation of First Amendment speech rights. And Justice Kavanaugh wrote for the majority that it is. So those limits are overturned. What does this mean for campaign spending? Will the same spending shift from what's called independent expenditures to will the same spending shift from what's called independent expenditures to party-labeled spending? And will we see overall spendings increase?
Yeah, it's really smart to bring up the independent expenditure groups because what's happening right now is, as we know, there's a ton of soft money and dark money way beyond the limits to individual candidates. A ton of that money is coming into the political system, but it's coming in through these groups that are separate from the parties. They're, to the side, kind of not supposed to be coordinating with the candidates, having a lot of independence, at least in theory. Now, a lot of that money could come directly to the Republican Party or the Democratic Party. Or the Working Families Party. And so it gives the parties the potential to raise a lot of money and kind of re-exert their control over the candidates. Because right now they're, pretty powerless in elections. But now, as Justice Kagan says in dissent, a donor could give a party as much as $500,000 compared to the $7,000 he could give directly to the candidate. And the candidate can seek the donation and it can all be coordinated. So she is arguing that the party is being allowed to serve as an alternative checking account for a campaign.
Now, this case was brought by the National Republican Senatorial Campaign Committee, but is there a partisan angle here? I mean, it clearly changes the rules for both parties, but, is that something that we're going to see a distinct advantage from one party or the other?
I mean, that's a really good question. I don't know. I think both parties are now going to try to convince mega donors to give to them instead of these independent groups. It's possible that one will have more success than the other because it has a better relationship with the donors, or it just seems like, it's more organized, we'll spend the money better. But it is certainly true that now all bets are off, or all limits are off, I should say, for all political parties.
Emily, today felt like, there was so much build up to some of these final decisions. Certainly the birthright citizenship case, not unlike when the court overturned Roe or legalized same-sex marriage. Do you think that they hold these big cases for the end, for the effect, or because they actually just take longer than some of those other cases?
They're not supposed to hold them for the effect. However, it does feel like they create a lot of suspense. I mean, in defense of holding back the birthright citizenship decision, there's a total of 194 pages in all the dissents and the majority opinion. So they were writing a lot. I sometimes wonder whether Chief Justice Roberts, who, is the chief, tries to end the term on a note where there are some wins, it looks like, for liberals and other wins for conservatives, and that creates an appearance of the court being kind of more balanced than I think it actually is, because it is a deeply conservative court. But I don't have any evidence for that thesis. It just is something that seems to happen every year.
Sure. Yesterday, President Trump seemed a little bit unhappy with some of the Supreme Court's opinions, certainly the one allowing mail-in ballots to be counted after Election Day and not allowing him to fire Federal Reserve Governor Lisa Cook at will. Also, the court decided not to take up his attempt to overturn the jury verdict in E. Jean Carroll's lawsuit against him. But in general, do you feel like this court has been more inclined to expand executive power or to rein it in?
Oh, much more inclined to expand it, no question. I mean, in circumstances in which they were much less sympathetic to cases that President Obama and President Biden brought. So first of all, I think you can see an inconsistency. And also the conservatives have just kind of gotten going on executive power. I mean, the best example of this was the decision yesterday about the Federal Trade Commission and how the president has the power to fire the heads of the commission. That is just an enormous change to how government works. And it reminds me of the decision in 2024 giving former presidents, immunity for most of what they do in their acts of office. It just really changed the whole understanding of the presidency and the separation of powers.
Speaking of changes, the president was not quiet about his disapproval. He made a lot of social media posts yesterday. This is a shift from presidential behavior. Are we used to seeing presidents being overly critical of Supreme Court rulings?
I mean, in the past, courts have criticized the rulings, but not the justices individually. So the idea is, I don't like what you did, but I still have respect for the institution, and I understand you are a co-equal branch. Trump has not abided by that norm. I think there's a way in which the court can be a kind of useful punching bag or, supposed opponent for Trump. They can't really push back. That's not their job. They don't get out there and go on television and respond to him. And it makes it look like he is trying to do what his base wants and being thwarted in a way that he can't control. And so, wait, you should just give me more power. So I'm not in this position vis-a-vis the court.
Just very briefly, Emily, our last question. We saw the court side with the Trump administration on immigration, except in this morning's birthright citizenship case and in the firing of the FTC commissioner, but not on constitutional grounds, meaning Congress could pass legislation to reverse the court in a way. Alternatively, they could pass the SAVE Act, which would accomplish what the mail-in ballot case did not and make it much harder for people to vote by mail. So as the co-host of the Political Gabfest, not just a legal scholar, would you give it a odds of congressional action in any of those areas being likely or unlikely?
I don't think Congress has the votes for the SAVE Act. The poor majority leader keeps telling the president that. Maybe someday, but they don't seem to have it now.
Well, we will wrap there. Thank you so much. My guest is Emily Bazelon. I'm Bridget Bergen. That's it for The Brian Lehrer Show today.